Notice of Default and Dishonor, a comprehensive report on its purpose, process, and legal standing. Introduction. A notice of default and dishonor is a formal written declaration used in legal, commercial, and administrative processes to establish that a party has failed to respond, rebut, or perform as required under an agreement, contract, or lawful notice. This notice is widely used in private administrative remedy procedures, contract law, and Uniform Commercial Code (UCC) processes. It serves as a vital tool for individuals and entities asserting rights, obligations, and remedies, especially when dealing with non-responsive, negligent, or adversarial parties. 2. Purpose of the notice. The core objectives of a notice of default and dishonor are to officially record a party's failure to respond or perform, serve as a final opportunity for the opposing party to cure the default, lay the groundwork for commercial enforcement, liens, or legal action, place the opposing party in administrative and commercial dishonor under UCC principles. 3. Legal foundation. A. Uniform Commercial Code, UCC. The UCC provides the legal underpinning for such notices. UCC 3501B requires presentment and notice of dishonor of negotiable instruments. UCC 1308 protects the right to reserve legal rights without prejudice. UCC 3505 defines dishonor and the conditions under which an instrument is dishonored. B. Contract law. Under general contract law, when a party fails to uphold its duties under an agreement or ignores a formal demand, they can be declared in default and dishonor. 4. Key elements of a notice of default and dishonor. Header and title. Clearly labeled as a notice of default and dishonor. Identification of parties. Claimant, the party issuing the notice. Respondent, the party in default. Reference to previous notices. Example, notice of conditional acceptance, affidavit of truth, or demand for proof of claim. Statement of default. Declares that the respondent failed to respond, rebut, or comply within the specified time. Statement of dishonor. Formally places the respondent in dishonor for failing to fulfill obligations. Consequences and intent to proceed. Outlines the next steps, such as certificate of non-response, lien filings, or judicial action. Affidavit or notary section. Includes notarization or witness signatures to validate the notice. V. Step-by-step process. Step 1. Issue prior notices. Notice of conditional acceptance or other lawful notice demanding response. Step 2. Wait the allotted time. Usually 10 to 30 days, depending on the nature of the original notice. Step 3. Draft the notice of default and dishonor. Detail the facts and the default. Include citations to applicable laws or agreements. Step 4. Serve the notice. Use certified mail with return receipt, private courier, or process server. Step 5. Retain records. Keep copies of all notices, mail receipts, and tracking confirmations. VI. Legal and commercial effects. A properly served notice of default and dishonor documents the respondent's failure to perform in good faith. Establishes a formal record of non-response or non-performance. Prepares the ground for enforcement actions, filing of a certificate of non-response, issuance of a commercial lien, administrative foreclosure, civil lawsuit or judgment. It may also support adverse possession, UCC filings, or international commercial claims. 7. Common applications. Private commercial remedies, trusts, debt validation, contractual enforcement, mortgage and debt disputes, administrative claims against government agencies, settlement of bills and commercial instruments, notice to trustees or fiduciaries. 8. Best practices. Maintain honor, civility, and professional tone in all correspondence. Keep a chain of documentation. Use a notary or 2 witnesses to confirm delivery and authenticity. Never make false claims. Stick to provable facts and verifiable documents. 9. Sample language, educational purposes only. This notice serves to inform you that, pursuant to prior notices issued on date, you have failed to respond, rebut, or perform as required. Your silence constitutes tacit agreement and dishonor. You are hereby placed in default and dishonor. Absent cure within 10 days of receipt, I will proceed to assert remedy and damages without further notice. X. Conclusion. The notice of default and dishonor is a powerful administrative and legal tool. When used properly, it places the recipient in dishonor and gives the sender a legitimate platform to pursue further remedies. It should always be handled with accuracy, integrity, and a clear understanding of applicable laws. By following proper procedure, individuals can protect their rights, expose unresponsive or unjust parties, and build a solid foundation for commercial or legal enforcement.